The court is ready to hear argument in 19-11-22, Kinder Morgan against Scurry County, from Scurry County and the 11th Court of Appeals District.
May it please the court. Mr. Heidler will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal.
May it please the court. As the Texas Attorney General concluded 21 years ago, Texas law and public policy do not authorize contingent fee tax ferret engagements. That's where a taxing unit hires a private party, the tax ferret, to search for property that has been omitted from taxation and pays that party as compensation some portion of the public tax revenue that he generates. The public policy problems are apparent from this case. These taxing units engaged Mr. Lemon to bring these claims where he says Kinder Morgan's property was omitted from taxation in exchange for 20% of the tax revenue he generates. This engagement has incentivized Mr. Lemon in the name of Texas government to engage in scorched earth tactics to try to maximize one taxpayer's tax bill when the Constitution requires equal and uniform taxation. No law authorizes this engagement. As this court explained in the Hollins decision, political subdivisions of Texas, like these taxing units, have only those powers that the legislature has expressly or impliedly conferred upon them. The taxing units here say that their engagement with Mr. Lemon is expressly authorized by Tax Code Section 6.30, which I reproduced in relevant part in my oral argument exhibits. Section 6.30 allows a taxing unit to engage a contingent fee attorney, quote, to enforce the collection of delinquent taxes. And the taxing units here say that Kinder Morgan's taxes are delinquent because they say Kinder Morgan's mineral interests were omitted from appraisal in prior years. So Kinder Morgan hasn't paid its fair share of taxes. But the concept of delinquent taxes has a technical meaning under the tax code, as pointed out in the amicus brief of the TTARA on at tab 3, where property is omitted from taxation and retroactively appraised. The taxes on that property do not become delinquent within the meaning of the tax code until the taxpayer receives a new tax bill reflecting higher.
Excuse me, Mr. Let's assume that we agree with you that this was not appropriate under the tax code, and that, you know, it's, quote, the fruits of the illegal activity. Wouldn't the cause of action be perhaps against the person who was acting as the tax ferret, or why would that result in a lack of subject matter jurisdiction over us?
Because under tax code section 4221, absent a valid appeal from the appraisal review board, the courts don't have subject matter jurisdiction. So in this case, we say that this tax ferret engagement.
But the appeal, Mr. Heidler, was filed by the county.
The appeal was filed by the county, so the question is whether the county has the legal authority to pursue an appeal through this kind of a tax ferret engagement. If you look at paragraph 1 of that engagement, paragraph 1 expressly charges Mr. Lemon with investigating and pursuing these very claims against Kinder Morgan. So the engagement is void, paragraph 1 is void, and the things Mr. Lemon did pursuant to paragraph 1 are also void and cannot be ratified, and that includes his filing of this appeal from the ARB.
What if the investigating was related to his role as an attorney? Can you draw the line that way?
So he says that he is not a tax ferret because the tax units hired somebody else, this Kindle firm, to do the initial investigation into these claims. But again, paragraph 1 of his engagement expressly charges him with investigating these claims. He's pursuing claims that post-dated what the Kindle firm did. So he's clearly done some investigation. So he unambiguously joined the investigation, even if he didn't start the investigation. They also say that he's not looking for omitted property the way that a tax ferret would do. But if you look at his petitions, he is expressly alleging that Kinder Morgan's property was omitted from taxation because he says the original appraisals of that property are void. So in the eyes of the law, the property was never taxed. And if you look at tab 5 of my exhibit, you can see This is a classic taxpayer strategy of trying to earn a contingent fee by increasing appraisals of oil and gas interests. So,
Mr. Heidler, assume all the same facts, but that the appeal was filed by a different attorney. Would there still be a lack of subject matter jurisdiction?
There would be, because there's a ratification problem. Under Brazel versus Murray, a void act cannot be ratified. So the taxing units don't have legal authority to engage the taxpayer. They also don't have legal authority to engage a taxpayer to do some of the work and then to ratify that work by hiring someone else to come in and take over where the taxpayer left off.
But how does that make the notice of appeal void? I'm not understanding that piece of your argument.
So the notice of appeal grows directly out of paragraph 1 of his engagement. So I would take the court.
My hypothetical was that he didn't file the notice of appeal.
Well, if he didn't file the notice of appeal, this taxpayer project that they've undertaken involves investigating these claims, pursuing these claims at the ARB, ultimately pursuing the claims in court. So if someone else were to come in and file that notice of appeal, they would be taking over the work that he did. That's not what happened here. Here we have a much easier case. He filed the notice of appeal, and he did it pursuant to this taxpayer engagement under this court's decisions in the Jayton Rural High School District case and the Childress versus Shelby County case. His actions are unauthorized and therefore they're void. I would point the court to Childress versus Shelby County, where the political subdivision entered an order creating a school district. This court held that the order was void, and as a consequence, the things that the trustees of the purported school district had done were also unauthorized. That means those actions would be void as well. So Mr. Lemon is here in the position of those trustees. He's been appointed to do something that the political subdivision has no authority to do, which is pursue his taxpayer project. So his actions are void and cannot be ratified. So that's the jurisdictional question. The jurisdictional question arises from the fact that this engagement is void because it's not authorized by Texas law, either by any express authority under Texas law or by any implied authority under Texas law. In the Hollins case, this court found no implied authority for the Harris County clerk to engage in the mass distribution of election ballot applications, in part because the election code expressly allowed private parties to do that, but was silent about whether a public official could do the same thing. Similarly here, Texas law expressly allows certain political subdivisions to enter into certain contingent fee contracts, all subject to strict regulation, but Texas law is silent about whether taxing units can enter into contingent fee tax-bearing engagements. The only fair inference is the one drawn by Attorney General Cornyn in the year 2000. Texas law does not authorize contingent fee tax-bearing engagements. So we ask the court to dismiss for lack of subject matter jurisdiction without reaching the TCPA issue. But if the court reaches that issue, the Court of Appeals erred in holding that the taxing unit's cursory 7-page original petition started Kinder Morgan's 60-day period to file a motion to dismiss. Under the TCPA, section 27003, that 60-day period does not begin to run until the defendant is served with a legal action that is based on, related to, or in response to the exercise of TCPA protected rights. Or in other words, as this court explained in the Lipsky case, the legal action must, quote, appear to stifle TCPA protected rights. Here, the original petition did not appear to stifle Kinder Morgan's rights. I've reproduced part of it at tab 6 of my exhibits. The original petition did not allege any conduct by Kinder Morgan at all. It stated that Kinder Morgan's property had been omitted from taxation in prior years and needed to be appraised. It was not until the second amended petition that the taxing units finally pleaded their factual theory of taxpayer fraud, that Kinder Morgan had lied to the Scurry County Appraisal District in the appraisal process. Those are the allegations that appear to stifle Kinder Morgan's right to communicate with and to petition the appraisal district.
Mr. Heidler, I assume you heard the earlier argument where we were talking about the difference between this sort of operative facts focus and elements of the legal claim focus. how would you apply that rubric to your argument here? Or did they add in that second amended petition both additional operative facts and additional legal claims, or just additional claims?
Just additional operative facts. And I would answer the question the way that Justice Boyd addressed the issue during the Montelongo argument. The term cause of action has been defined by this court as the set of operative facts giving rise to a claim for relief. And so when the second amended petition announced a new set of operative facts for the first time, putting us on notice that they were relying on a factual theory of taxpayer fraud, those facts constitute a new cause of action under the TCPA, and therefore they are a new legal action.
Mr. Heidler, had you had any indication that there was an allegation of fraud maybe that came up at your client at the ARB hearing, or no?
So we have had a couple of what you might call indications of fraud. Back in 2014 or 2015, we exchanged a few letters with different lawyers. They never pursued any claims against us. And then Mr. Lemon comes in and at the ARB hearing, which I have portions of it reproduced at tab 8 of my exhibits, and I'd encourage you to look at these. It's really informative. He never alleged that Kinder Morgan committed taxpayer fraud. All the lawyers talked about fraud a lot in the hearing. He'll say they said the word fraud so many times. That happened, but when it came time to explaining factually what had occurred here, he never factually alleged that Kinder Morgan committed taxpayer fraud. In fact, he said he didn't know what had happened. He said, I'm not going to tell you what the commercial appraiser, that's Pickett, did inaccurately. We don't have that information. The commercial appraiser Pickett missed $14 billion worth of oil reserves. We don't know why. We don't know where the errors are. Whether there was a misunderstanding between Kinder Morgan and the commercial appraiser Pickett, or between Pickett and the appraisal district, we don't know. So he never alleged taxpayer fraud at that hearing. And more importantly, under the language of the TCPA, what matters is what the legal action filed in court says, not what was said in some prior hearing. The original petition filed in court said nothing about Kinder Morgan's communications, about fraud, about misrepresentation, or anything like that.
And Mr. Heidler, I just had a practical question, not so much for your case maybe, but if you're going by just facts alleged in an original petition and not looking at causes of action, and you're looking to see whether you have coverage, I mean, there's a big difference between being sued for negligence and fraud. And I'm just not sure how you'd be able to tell whether you actually had coverage for some of the facts if they're not couched as claims.
Well, under the TCPA, a new set of operative facts gives rise to a new cause of action, which is a new legal action which resets the deadline. That's how the defendant knows that it has an opportunity to file a motion to dismiss, because it's on notice of the factual theories that are pleaded. Now, if the claims change, as in Montelongo, there is also a new set of operative facts, right? Because different elements must be proven. Both claims might arise out of the same transaction or occurrence, but the claims are going to be different because there are new operative facts, because there are new elements in most situations. So we're not advocating an exclusive rule for the TCPA. We're saying on the facts of this case, in cases like this one, where the original petition does not allege any conduct that would come within the TCPA, the 60-day clock doesn't start to run until that kind of a factual theory is alleged. Now, I want to touch on the Court of Appeals holding regarding special exceptions. The Court of Appeals said the original petition must be broadly construed because Kinder Morgan did not file special exceptions, but the claim alleged in the original petition is not valid under Texas law. A claim to appraise omitted property where that very property is already present on the tax rolls. So we filed a motion to dismiss under Rule 91A, but that motion did exactly what special exceptions would have done. It pointed to particular paragraphs, it identified all the pleading defects, including that the taxing units had not said who was responsible for these alleged problems in the appraisals, and that the taxing units hadn't pleaded any facts to put Kinder Morgan on fair notice. Now, the taxing units in response did exactly what they would have done in response to sustained special exceptions. They amended and they stated their pleadings, and they finally pleaded their factual theory of taxpayer fraud, because without alleging taxpayer fraud, they had not stated a viable cause of action or claim under Texas law. So we asked the court to dismiss this suit for lack of subject matter jurisdiction, or in the alternative, to reverse the order denying Kinder Morgan's TCPA motion to dismiss and to remand for further proceedings. Thank you.
Any other questions? Thank you, Mr. Heidler. We'll hear from the respondents.
May it please the court, Mr. Lemon will present argument for respondents.
May it please the court. It is noted that the assertion of a tax ferret agreement in this case was not brought until a year and a half after the litigation had been proceeding, and indeed the trial court had ordered expedited discovery and an expedited trial setting. It was only at that time that the Kinder Morgan parties brought this issue before the court, and they did not even raise it in their original petition to this court. There simply is not a tax ferret agreement in this case. We can begin by simply looking at the definition of a tax ferret that Kinder Morgan provides on page 10 in its brief. Kinder Morgan stated, a contingency fee tax ferret is a private entity who contracts with a taxing unit to locate property omitted from the tax rolls and receives as compensation for his services a percentage of all tax revenues generated by the tax ferret. In this case, there is no question that the properties are on the tax rolls. The issue has to do with Kinder Morgan making representations to the federal authorities and other filings that are not consistent with the values that are shown by the taxing units in Scurry County. Additionally,
Mr. Lemon, I'm not sure I'm understanding that. They said the property was omitted, but you're saying it was not omitted?
The property, in order to pursue a claim for fraud relative to property, it is a legal theory that has been presented that properties are omitted ab initio. So the properties actually are listed on the roll. They are just at the wrong value, the insufficient value. And what the courts have decided, this court in Willacy affirmed that was the procedure to take, is that the courts will look back and assume that since fraud was involved, that the entire appraisal was void. So these properties are listed on the tax rolls. They're just at the wrong amount due to the misrepresentations of the taxpayer.
So Mr. Lemon, with respect to this transaction, did you act as a tax ferret at any time?
I did not. I acted as an attorney representing these taxing units. And in fact, I'm sorry.
Okay, so, and did the contract, though, encompass a role for a tax ferret, even though the assertion today is that you did not act in that capacity?
It did not. The contract provides that there would be an investigation and review and pursuit of the claims. Those are the services of an attorney. The taxing units, as we can show by tab number 1, Judge Kendall's letter, which in the subject line says mineral interest misrepresentation. The taxing units were the ones who originally located these deficiencies or inadequacies relative to the values based on federal public filings versus the value that were calculated in Scurry County. So at no point and at no time was I engaged in any way to locate properties. My job is to represent these taxing units as they pursue their claims as required under the tax code. In fact, the lead counsel for Kinder Morgan responded, and this is tab number 2, responded to Judge Kendall and said, you have to pursue any of these claims under the tax code. And so that is what I was engaged to do. So there is.
So if we conclude that you actually in fact engaged in a different activity, do you concede that you didn't seek the appropriate approval from the comptroller?
I do not concede that the pre-approval was required of any of the 4 clients. To begin with, the school district has an express statute that allows the school district to engage someone to collect taxes on any terms that it deems is appropriate. And furthermore, the political subdivisions.
Can the school district engage more than one such person? If there's already a tax assessor collector in place, can there be more than one?
There can be more than one. There is no limitation that says you can only have one tax assessor and collector. And in fact, the role that I was engaged relates to the collection part and not to the assessment part. I was engaged to present the claim to the ARB and to the district court in order to have the properties properly appraised. Furthermore, the 3 political subdivisions were not required prior to August 1 of 2019 to have any type of pre-approval, either by the comptroller or by the attorney general. And contracts prior to that date are not subject to any of the approval. The county did have a situation where, if it was not exempt, should have been submitted for pre-approval to the comptroller. However, the 6.30 of the tax code allows the pursuit and collection of delinquent taxes to engage those on a 20% contingency fee, which that happens on a regular basis. And that is why the county also did not have to have the pre-approval. So none of these contracts required the pre-approval.
What's your response to the point from that that your opposing counsel mentioned, and from the amicus brief, that there weren't any delinquent taxes in this under that the technical meaning that term has under the tax code?
Well, there are 2 responses to that. Number one, there were actual tax bills sent, but the tax bills were sent in a insufficient amount due to the fraud. The other is that taxes are due on February 1st of the next year, and as this court stated in Atascosa, that the obligation to pay taxes is always there. And so Kinder Morgan is attempting to say, we successfully defrauded the appraisal district to where they didn't put the amount we owed on a tax bill, so therefore it was not delinquent. And that just isn't the case. The other issue is this court in the White case, in interpreting a prior tax ferret law that was repealed but then partly reinstated, the court said that the term delinquent taxes is one that should be broad and not a highly technical term. So in this case, Kinder Morgan is essentially seeking to capitalize upon having been successful at misrepresenting the value of their property to the taxing authorities. Further, this court has held that counties, through their county commissioners, have the right and the duty to take any reasonable measures, including hiring counsel, in order to pursue their duties and their obligations. So what the court really should be looking at relative to jurisdiction is, did the taxing authorities or taxing units have authority to actually bring these claims? And that's clearly yes. Mr. Rodriguez's letter even said so. You can look at tab 15, which is 41.03, expressly says that a challenge can be brought as was pursued. And tax code 43.01, which is tab 16, allows the taxing units to actually sue the appraisal district. And we also have in this court, as I've mentioned, Atascosa and the Willacy case. Both of those indicate that these taxing units have the authority to go ahead and to pursue these types of claims. Indeed, one of the cases that I cited in my petition, the petition for the taxing units, cited to the ExxonMobil case, which was an oil case, somewhat similar to this one, and it sets out the roadmap for how to pursue these types of claims. And we followed that roadmap. So the real question on jurisdiction is, did the taxing units have authority? And the answer is clearly yes. The other issue is that the employment terms have nothing to do with jurisdiction. Kinder Morgan attempts to conflate those two items into one. At most, any of these employment issues may have an effect at the end of the day on the compensation. They do not have any effect on what has transpired, or rather the jurisdiction. This is somewhat similar to in Pike and Cook, which the court recently issued relative to a capacity complaint. It is not a jurisdictional issue, and the employment terms in this case are not a jurisdictional issue. They don't relate to it. In fact, if such were the case, then perhaps the Murrin brothers and the Hill versus Shimon case would have turned out completely different. If the court did not have jurisdiction in the Murrin brothers, then obviously it would have had to have looked at that issue first if it was a jurisdictional issue where the board had to be unanimous to hire the attorney. In the Shimon case, this court found that an oral contingent agreement was not valid, but then sent it back because it said that there was a question on quantum merit. So in this case, the actual filing of the appeal and the filing of the de novo appeal to the trial court, all of those occurred regardless of any employment issues. There just simply is not a jurisdiction case before the court, jurisdiction issue before the court today. With regard to the TCPA, the analysis of this actually begins with what Kinder Morgan's attorneys have said. And you can begin at tab 7. Tab 7 was a filing that was made before the TCPA filing was brought, but after the suit had been filed. And what it does, it explains that, yes, the cases that were cited in the petition, this is what they stand for. There's only one viable cause of action, and Kinder Morgan knew on the day that they got the pleading exactly what the issues were. Indeed, when being argued to the Court of Appeals, Kinder Morgan's counsel conceded that, yes, they knew what those cases stood for, that they were tax fraud cases. The other admission that we have is I have under tab 8, and tab 8 is in fact shows that Kinder Morgan considered filing a TCPA motion earlier, but made a conscious decision because they did not want to be exposed to the limited liability that the TCPA allows. So with that in mind, there's really no dispute, I don't think a valid dispute, that Kinder Morgan knew exactly what this case was about. They had attended the ARB hearings, they had received the Kindle letter, they had been resisting production of their free speech renditions for years and continue to this day to do that. But the next area that we would
should we be able to look though outside the petition to decide whether the legal action implicates one of the protected rights?
That was the area that I was going to next. And to answer your question, I think the answer is yes. And
what in the statute allows us to do that?
well, to begin with, we look at the definition of a legal action, and that in relative to this case is a lawsuit, a cause of action, or a petition. So we have the petition. The second, and this is what I was actually trying to focus on more, and this is why I think you can go outside the record, is if the legal action is based on, relates to, or is in response to. And that's why I think this court can look at what was the claimed free speech. And the trial court said the claimed free speech of these renditions, that's been at issue since the inception of the case. And it has in fact been at issue even before then. So I think that my analysis would be that you look more at the free speech item instead of the pleading, or you look at it first and then you look at the pleading. In this case, there's no valid dispute that the renditions were the supposed free speech. There's no valid dispute that the renditions were purposely submitted to the appraisal district for reliance. And so when you look at it that way, then you can look at the original petition, knowing, okay, what is the free speech and how does it relate to this issue? And if you look at the pleading itself is very clear with regard to what the case is. The way the notice pleading works is that it is a reasonably competent attorney standard. And any reasonably competent attorney would have looked at this pleading, would have read the cases if they didn't already know them, which in this case, Kinder Morgan had been arguing them for 6 months, and know there was only one viable cause of action that even exists, and that is that there is an omission that resulted from taxpayer fraud. And we know, I'm sorry.
Mr. Lemon, do you think that the taxpayers in a particular county have an interest in knowing whether the taxing entities are hiring tax ferrets and, maybe without any authority to do so, and looking for things, in a way that's not authorized by law? Don't you think the taxpayers have a right to know that, if that's what happened?
Well, we don't believe that happened, but all of these attorney fee agreements were negotiated with the taxing unit's attorneys who are knowledgeable in this area, and notice was given, and there were meetings held, board meetings. All of my clients have boards, and they're run by boards, and Kinder Morgan attended at least half of those, if not all of those, and was there whenever these agreements were being reached, and they were placed in the newspaper. The newspaper, you saw the newspaper article. So if you look then at what this case is about also, it is a statutory appeal under the tax code. It's not anything else. It's not fraud. It's not common law fraud. It's not anything. It all has to go under this statutory review. And that is what we did. So when Kinder Morgan got the petition, and we know, if you look at tab number 5, what happened after Kinder Morgan was served, Kinder Morgan's attorney, again, Mr. Rodriguez, who had received the Kindle letter in exchange, he says that he sent a letter to the Attorney General. He says the renditions are in fact the basis of the valuation. He attached a letter from the appraisal district who said, we take verbatim the expenses that Kinder Morgan gives us. And he attached, very significantly, he attached as Exhibit B to his letter an affidavit from Kinder Morgan 1 week before they filed the answer that said, we provide all of the elements for the valuation of these properties to the appraisal district for reliance. So they knew that their free speech was at issue when they got served. They confirmed it with their letter to the Attorney General, which is exhibit number 5. And there is no doubt that they were well aware of what was going on. If you look at the specific type of suit this is, which is a de novo appeal, you will see it asks for the same relief, had the same parties, and is the same one cause of action. 41.03A2 is the only cause of action. And so the second amended petition asked for the exact same relief, except for asking for the court to go ahead and start ordering discovery because it had been shut off and stayed with every single motion filed by Kinder Morgan to that point.
Any other questions? Thank you, Mr. Lemon.
Thank you.
Mr. Heidler, you have 5 minutes.
May it please the court, let me start with Mr. Lemon's comment that Kinder Morgan has taken the position that it successfully defrauded the appraisal district. There's no evidence of fraud here. At the ARB hearing, let me back up. The taxing units are not claiming they've been defrauded. They are claiming that Kinder Morgan defrauded the appraisal district. At the same time, they're admitting at the ARB hearing that they have not even seen those communications. So on what basis they would have to state that kind of a claim, I don't know. The appraisal district, chief appraiser Larry Crooks testified at the ARB. He said, I'm not aware of any fraud having been committed. He has all the communications. Stephen Campbell, the 15-year oil and gas appraisal expert who specializes in these large, complicated tertiary recovery projects, he said he's not aware of any fraud having been committed. He also said that it would be really easy to badly overstate the value of these old oil and gas interests if someone just plugged in numbers from public filings without understanding the rates of decline and the high capital costs required to maintain production in a CO2 tertiary recovery project. He said he's not a taxpayer. I dealt with that in my opening argument, but let me make this point. What you call this engagement at the end of the day doesn't matter. Our point is they don't have express or implied legal authority for this engagement, and this engagement raises all the public policy problems inherent in tax ferret agreements. Now, he is a tax ferret. He is alleging that our property was omitted from taxation. He's been hired to establish that the property was omitted from taxation. It's on the tax rolls now. His job is to show it's been omitted. So he is doing what a tax ferret would do. He's been expressly hired to investigate these claims. And the name of the agreement doesn't matter. He mentioned the education code as potentially allowing the school district to engage him. That provision allows a school district to hire a tax assessor collector. A tax assessor collector has no authority to do what he is doing here, which is trying to add property to the tax rolls or change the appraisal value of property that is already on the tax rolls.
Mr. Heidler, are contingency fee agreements typical in if you were to hire someone in the capacity of an attorney in these types of cases?
So typical no. So years ago, there was a big problem with contingent fee tax ferrets. Courts and legislatures largely shut that down. We've seen recently a resurgence of these. So that's what we're worried about in this case, is a little cottage industry starting that would go after the oil and gas companies like we're seeing the taxing units do here. But what you see is debt collectors, right? Attorneys acting as debt collectors, which is what 6.30 is talking about. After the taxpayer's gotten a tax bill, has had a chance to pay it and hasn't paid it, then penalties and interest accrue. As the TTARA points out, that's what the tax code's talking about when it refers to delinquent taxes, not property's been omitted from taxation and the taxpayer just gets a bill later. To have a delinquent taxes, there has to be a tax bill sent that the taxpayer doesn't pay on time. He says that the taxing units have authority to pursue these claims. TTARA of their amicus brief says they don't. They say the 79 overhaul of the property tax code basically erected a wall between taxing units and appraisal districts. The appraisal districts are neutral. They're charged with finding the market value of the property. Taxing units are partial. They want to maximize their tax revenue. So the legislature separated those functions. So the TTARA says no taxing units can't bring this kind of claim. We're not going that far. We're just asking the court to rule that a taxing unit can't enter into this kind of contingent fee taxpayer engagement, leading to litigation targeting one taxpayer with this scorched earth tactics that we've seen here.
Counsel, what's your response to the argument that taxes are owed in some sense and therefore delinquent if not paid, even if they have not been billed?
So taxes absolutely are owed. I would point to the plain language of the statute, section 6.30. It does not use the colloquial word owed. It uses the term delinquent, which is a technical term under the tax code. It's a clear reference to the delinquent tax provisions. And so you have to look at those provisions, and there's express language from the legislature that, in my oral argument exhibit saying the taxes are not delinquent on omitted property until the taxpayer receives the bill and doesn't pay it within 180 days. So there are no delinquent taxes here. He says employment issues are just irrelevant to the jurisdictional issue. That just flies in the face of black letter law from this court in the Childress versus Shelby County case. His engagement is void, and that makes the things he did under the engagement, including the filing of the appeal, void. Thank you.
Any other questions? Thank you, Mr. Heidler. The case is submitted and the court will take another brief recess.